Alice Lewis. I'm the president of the Plato Society, and I want to welcome you. I want to welcome you to the 6th colloquium that we've put on this year as part of our colloquium program. If you are not a member of the Plato Society and would like to know more about us, you will find these brochures on the table outside the door. And you can look us up on our website, theplatosociety.org. We welcome any inquiries you might have about what we do and how we do it, and encourage you, if you're interested, to get in touch with us. Okay, with that, I will turn this over to Terry Ponchek, who has been the chair of the colloquium committee this year and has done a terrific job.
Hi, everybody. So in true Plato Society style, first of all, happy St. Patrick's Day. I'm not losing the opportunity to make this an extraordinary learning experience. I have a couple of facts about St. Patrick's and St. Patrick's Day that I'm going to share with this captive audience before the dean starts speaking. First of all, St. Patrick was not Irish. He was from Wales or Scotland, although he was held as a slave by the Irish when he was a child. The first St. Patrick's Day parade took place in 1760 in New York. There are an estimated 34 million Irish descendant people in the United States and only 4 million in Ireland. So in a sense, there are more Irish here than there. And for many, many years, the color associated with St. Patrick was not green, it was blue, which is why the Irish presidential standard is still blue. And for many, many years, green was considered unlucky. Before, I'm guessing in a commercial decision, it became lucky. So anyway, I don't know if those are new facts to any of you, but I thought I'd share them. It's now my very great pleasure to welcome back to Plato Dean Erwin Chemerinsky, one of the top constitutional law scholars in the nation, and the dean of the UC Irvine School of Law. He has very kindly agreed to come speak to us today about some very important and complex issues and cases that are in front of the Supreme Court or in front of other courts around the country. Cases that could have a profound and chilling impact on elections as well as the way our government works. While some cases have whipped the American people to violence and protest, most obviously the cases about the tension between women's rights to choose and the right to life, others are moving more quietly and stealthily through the system, with the proponents hoping to make profound changes about who's allowed to vote and where they're allowed to vote. Cases on voter fraud or voter suppression, depending on your point of view, gerrymandering, and the way the census is counted may not seem sexy, not even cross the consciousness of many people, or seem important to others, but they are among some of the most important issues facing us today. The recent death of Justice Scalia has only made this particular moment in our history more complex, polarizing, and fascinating. How will the court affect the election? How will the election affect the court? What will happen to the court and the Senate now that Justice Scalia has died? Please join me in issuing a warm welcome to Dean Chemerinsky while he offers us some insight into these questions.
Perfect. Thank you so much for the very kind introduction and the really warm welcome. The single most important issue in the November presidential elections should be who is likely to fill 4 vacancies on the United States Supreme Court. The average age which a justice has left the Supreme Court since 1960 is 79 years old. By coincidence, that was Justice Scalia's age when he passed away on February 13th. Yesterday, Ruth Bader Ginsburg turned 84 years old. Later this year, Anthony Kennedy will turn 80 years old. Stephen Breyer will turn 78 years old. There is one likely vacancy already for the next president to fill. There seem almost surely 3 more, especially if the next president serves for 2 terms. So what I want to talk about is, what is the effect of the Supreme Court with regard to this election? How will this election affect the future of the Supreme Court? I thought that I would address 4 points in my remarks. First, I want to talk a bit about the legacy of Justice Scalia. Second, I want to talk about the cases this term on the Supreme Court's docket and what Justice Scalia's passing is likely to mean for them. Third, I want to talk about the process for filling this vacancy on the Supreme Court. I always knew that the Plato Society had a great deal of influence, but it's amazing that they get President Obama yesterday to pick Judge Garland so we could speak about him today. And fourth, I want to spend a good deal of time talking about why this election is so important, not just for the future of the Supreme Court, but for all of our rights. It seems only appropriate, though, to spend a moment talking about Justice Scalia. He was appointed to the Supreme Court by President Ronald Reagan in 1986. He served for almost 30 years on the court. Obviously, it's years or decades to be able to assess his legacy. To a large extent, that's going to depend on who replaces him and who fills other vacancies that are likely to occur in the years ahead. But still, I think we can talk some today about what was Antonin Scalia's impact on the Supreme Court. I think it's possible to identify areas where he was successful, areas where he was partially successful, and areas where he failed. There are some areas where he was notably effective. The Second Amendment. From 1791, when the Second Amendment was ratified, until June of 2008, not once did the Supreme Court find any law, federal, state, or local, to violate the Second Amendment. In the few Second Amendment cases prior to 2008, the Supreme Court always said the Second Amendment means what it says. It's a right to have guns for the sake of malicious service. The Second Amendment says a well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Justice Scalia was always a critic of that view. He believed that the Second Amendment should include a right of individuals to own guns and have them at least in their homes for the sake of security. And in June 2008, Justice Scalia wrote the opinion for the court in District of Columbia versus Heller. This case involved a 35-year-old District of Columbia ordinance that prohibited private possession or ownership of handguns. The Supreme Court, in a 5-4 decision, declared this law unconstitutional, proclaiming, as Justice Scalia long expressed, the Second Amendment is a right of individuals to have guns, at least in their home, for the sake of security. Another area where Justice Scalia was successful was in striking down laws regulating campaign finance. The most famous of these cases, of course, was Citizens United versus Federal Election Commission, where the Supreme Court in 2010 held that corporations have a First Amendment right to spend unlimited amounts of money out of their treasury to get candidates elected or defeated. In fact, Justice Scalia was in the majority in case after case that struck down laws regulating campaign finance. Then there were the areas where Justice Scalia was partially successful. Abortion rights. From the time Antonin Scalia came on the Supreme Court, he was a vehement spokesperson for the view that there is no constitutional right to abortion. He strongly opposed Roe versus Wade. In literally every abortion case, in his almost 30 years on the Supreme Court, he urged the court to overrule Roe versus Wade. It never happened. He never got more than 3 other votes for that position. But he was part of a majority to limit abortion rights and allow much greater government regulation of abortion. The most recent abortion case was in 2007. It's a case called Gonzalez versus Carhart. The Supreme Court, 5-4, with Justice Scalia in the majority, upheld the federal Partial Birth Abortion Ban Act. It prohibits an abortion procedure that's relatively rare, what the doctors say is often the safest form of abortion for women is they near or just after viability when abortion is essential. Affirmative action. Justice Scalia was a strong foe of all forms of affirmative action. He believed that the Constitution required that the government always be colorblind. He never could get 5 votes for that position to eliminate all affirmative action. But he was successful in being a majority that limited affirmative action, that it made it much more difficult for the government to use race to remedy past discrimination to enhance diversity. Then there are the areas where Justice Scalia failed. Gay and lesbian rights. Justice Scalia dissented in every Supreme Court case in history that advanced gay and lesbian rights. Most recently, on June 26, 2015, Justice Scalia wrote an angry dissent in Oberfeld versus Hodges. There, the Supreme Court declared unconstitutional laws in Kentucky, Michigan, Ohio, and Tennessee that prohibited same-sex marriage. There, the court held that same-sex couples have the constitutional right to marry in all states and all territories of the country. Another place where Justice Scalia failed was with regard to his theory of originalism. His belief was that the meaning of a constitutional provision was fixed when it was adopted, that the meaning of a constitutional provision could change only through amendment. Never did a majority of the court accept that view. In fact, Justice Anthony Kennedy's majority opinion in Oberfeld versus Hodges, the marriage equality case, expressly repudiated originalism. The court has always believed that the Constitution is a living document. Chief Justice John Marshall in McCulloch versus Maryland in 1819 said, "We must never forget that it's a Constitution we're expounding, a Constitution meant to be adapted and evolved for ages to come." It's easy to see why the Supreme Court has taken this position. Look at Article 2 of the Constitution. It refers to the president and vice president with the pronoun he. There's no question that the framers of the Constitution intended the president and vice president would be male. Does that then mean, if you're an originalist, it's unconstitutional to elect a woman as president or vice president until the Constitution is amended? The same Congress that ratified the 14th Amendment also voted to segregate the District of Columbia public schools. If one was truly being an originalist, then Brown versus Board of Education was wrongly decided. That's why a majority of the court never was willing to embrace Justice Scalia's originalist philosophy. For so many other opinions written by Justice Scalia. Yeah. Okay. Plan B. For so many other opinions written by Justice Scalia, we'll need to wait and see what future courts do. And that really will determine Justice Scalia's legacy in constitutional law. Well, the second thing that I wanted to talk about is, what about the cases that are pending before the Supreme Court this term? I have heard a great deal of misinformation. In fact, I almost got in a car accident when I heard someone on the radio say something that was completely false. I almost ran into the car in front of me. Let me start with that. In order for a justice to participate in a decision, he or she must be on the bench the day the case comes down. Justice Scalia's vote does not count in any cases that had not been released as of February 13th, 2016. That is clearly established even as to the cases where Justice Scalia was there for oral argument and voted. Well, this then raises the real prospect, as I'm going to talk about, of 4-4 splits this term in the Supreme Court. To give you some statistical context, last year the Supreme Court decided 66 cases after briefing and oral argument. 19 of them were resolved 5-4. What happens if the court splits 4-4? It's not unheard of for a justice to be absent from the court, maybe because of a conflict of interest, maybe because of illness, maybe because of vacancy. So this won't be the first time there's been possibility of 4-4 splits. The Supreme Court has two options. One is it can let the lower court decision stand. The technical phrase for this is that the lower court is affirmed without opinion by an evenly divided Supreme Court. The Supreme Court simply does nothing, lets the lower court decision remain. There's no Supreme Court precedent. Sometime in the future, the Supreme Court can revisit the issue. The other alternative is the Supreme Court can put the issue over for re-argument next year. There are some very famous instances where the Supreme Court has put a case over for re-argument. The tradition is that any case that's argued in one term of the Supreme Court is decided that term. So we are now in October term 2015. It's expected that all the cases argued this year be decided by June 30th. But sometimes the cases argued in one term get put over, get re-argued, and decided the next. Brown versus Board of Education. Brown versus Board of Education was argued to the Supreme Court in October term 1952. The justices could not come to a consensus. They decided, rather than resolve the case, to have it put over for re-argument and decided the next year. In the summer between those two terms, the summer of 1953, the Chief Justice, Fred Vinson, died of a sudden heart attack. President Dwight Eisenhower made Earl Warren a recess appointment as Chief Justice. Earl Warren presided over the oral arguments in Brown as a recess appointment, not having yet been confirmed by the United States Senate. The court then decides the case in October term 1953. In fact, on May 17th, 1954, the court handed down its historic ruling in Brown versus Board of Education. Roe versus Wade. Roe versus Wade was argued to the Supreme Court in October term 1971. That year, there were only 7 justices on the Supreme Court. Justices Hugo Black and John Marshall Harlan had left the court. They had not yet been replaced by Lewis Powell and William Rehnquist. The 7 justices decided they didn't want to resolve such an important, controversial issue with only 7 justices there. So they put the case over for the next year. It was argued in the fall of 1972, and then Roe versus Wade came down in January 1973. Citizens United versus Federal Election Commission. It was originally argued to the Supreme Court in October term 2008. The justices decided they wanted new briefing and argument on a First Amendment issue. The case was re-argued in September of 2009, decided in January 2010. So the justices can choose to put cases over for re-argument. It takes 5 votes to put the case over for re-argument. If it's split 4-4, the lower court decision, whatever it is, stands. It'll be interesting to see which of these options the court takes and for which cases. Let me remind you of some of the most important cases that are before the court this term, where Justice Scalia's absence can make an enormous difference. Friedrichs versus California Teachers Association. In 1977, in a Bood versus Detroit Board of Education, the Supreme Court reaffirmed that no one can be forced to join a public employees union. But the court said that non-union members can be required to pay the share of the dues that go to support the collective bargaining activities of the union. The court said non-union members benefit from the collective bargaining. They benefit in their wages, their hours, their working conditions. The court said they shouldn't be able to be free riders. But the court said they don't have to pay to support the political activities of the union. To force someone to support political activities with which he or she disagrees would be impermissible compelled speech. In recent years, in 2 cases, the 5 most conservative justices have sharply criticized a Bood versus Detroit Board of Education. In Knox versus SEIU in 2012, and then Harris versus Quinn in 2014, 5 justices indicated a likely willingness to overrule a Bood. Friedrichs versus California Teachers Association was filed to be the vehicle to overrule Abood. The case was filed in federal court in Orange County. The lawyers for Friedrichs, the National Right to Work Committee, went to the federal district court judge, Josephine Staten, and asked her to overrule the Supreme Court's decision in Abood versus Detroit Board of Education. She said, I'm just a federal trial court judge. I can't overrule the Supreme Court. They said, that's right, you can't overrule the Supreme Court, so just rule against us so we can get to the Federal Court of Appeals. Went to the Federal Court of Appeals, and the lawyers for Rebecca Friedrichs, National Right to Work Committee, said to the Federal Court of Appeals, overrule Abood versus Detroit Board of Education. The Ninth Circuit said, we can't overrule a Supreme Court case. They said, that's right, rule against us so we can get to the Supreme Court. The Supreme Court granted a review on June 29th, 2015. It's an unusual case in that there is no record. Nothing happened in the lower courts besides what I told you. Case was argued on Monday, January 11th of this year. I have rarely read a transcript of an oral argument which was clearer as to what the result was going to be. Not one of the 5 conservative justices then on the court, Robert Scalia, Kennedy, Thomas, or Alito, asked a single question or made a single comment that left doubt as to how they were going to vote. I can only imagine on Saturday afternoon, February 13th, how the lawyers on both sides of this case felt. Undoubtedly, their first reaction was sympathy for Justice Scalia's family. But then, for the lawyers for Rebecca Friedrich and the National Right to Work Committee, they surely saw victory being snatched away from them. And for the unions, the California Teachers Association, the defeat being taken away. And at this point, the court is split 4-4. If the Supreme Court affirms without opinion by an evenly divided court, the Ninth Circuit opinion stands, Abood remains. This is a huge victory for unions. Or the court could put it over for re-argument next term. But once more, we have to wonder, is it any more likely we'll have a 9th justice next year than we do this year? Second area that I would identify for this term involves apportionment and districting. It's a case called Evanwell versus Abbott. You've all heard the principle, one person, one vote. It comes from Supreme Court decisions in the early 1960s. It means that for any elected body that has districts, all districts must be about the same in population. There's 15 city council districts in Los Angeles. All have to be about the same in population. There's 5 districts for the Los Angeles County Board of Supervisors. All have to be about the same in population. After he finished his tenure as Chief Justice of the United States, Earl Warren was asked, what were the most important cases while he was there? Without hesitation, he said, the one person, one vote cases, because they let democracy work. Well, the challengers in Evanwell versus Abbott, case coming out of Texas, argue that districting should be based on eligible voters, not based on population. Think of a city like Los Angeles that has a significant population of those who are not citizens, both documented and undocumented. Also, there's a significant number of individuals, because of a prior felony conviction, are permanently disenfranchised from voting. If the challengers win and districting has to be based on eligible voters, it will have a substantial detrimental effect on the political strength of minority communities and of cities. It will help suburban and rural areas. Immediately, the Los Angeles City Council, Los Angeles Board of Supervisors, the California State Assembly, the California State Senate will have to be reapportioned. Case was argued in the Supreme Court on Tuesday, December the 8th. At the oral argument, Justice Alito expressed strong agreement that districting should be based on eligible voters. Justice Sotomayor expressed strong agreement with the view that districting should be based on population. Might this be 4-4 without Justice Scalia participating? Third area to focus on this term is reproductive freedom. And there are a couple of important cases about reproductive rights. One was argued a couple of weeks ago, the other will be argued next week. The one from a couple of weeks ago is Whole Women's Health Center versus Hellerstedt. Texas adopted a law a couple of years ago that says in order for a doctor to perform an abortion, he or she has to have admitting privileges at a hospital within 30 miles. Generally, the hospitals will not give these doctors admitting privileges. The other provision says that any facility where abortions are performed must have surgical quality facilities, even if no surgical abortions are performed there. Even if they're only providing medically induced abortions, like through RU 486, they still have surgical level facilities. It's estimated that this would close about 80% of all the facilities in Texas where abortions are performed. If these kinds of regulations are allowed, it's estimated it will close all of the facilities in states like Mississippi and Louisiana. A federal district court judge in Texas issued a preliminary injunction. He said there is no evidence whatsoever that these regulations will protect the health of women. He said these were regulations designed just to obstruct access to abortion. The United States Court of Appeals for the Fifth Circuit reversed and said, we should defer to the legislature in its judgment about whether these regulations protect the health of women. Courts should not make their own determination. The Supreme Court granted review. There is no doubt that Justice Scalia would have voted to uphold these regulations. He voted to uphold every abortion regulation to come in his 30 years on the court. I think that it's likely that Chief Justice Roberts and Justice Thomas and Alito would also vote that way. I think they would vote to overrule Roe versus Wade. On the other hand, I think it's clear that Justices Ginsburg, Breyer, and Kagan will vote to strike down the Texas law. It comes down to Justice Kennedy. Will it be 4-4, in which case the Fifth Circuit decision stands, the Texas law can go into effect? Will Justice Kennedy join the liberal justices here? That's what we'll see. The other case about reproductive freedom is going to be argued next week. It's a case called Zubik versus Burwell. It involves the so-called contraceptive mandate under the Affordable Care Act. The Patient Protection Affordable Care Act, often called Obamacare, has a provision that called on the Department of Health and Human Services to promulgate regulations to make sure that employer-provided insurance also had preventative health care coverage for women. We all know that traditionally insurance coverage was available only when somebody got sick. Congress wanted to make sure that insurance provided by employers had well care coverage for women. The Department of Health and Human Services promulgated the regulations. One part of them deals with contraceptive coverage. And that has three aspects. The first said, for a religious institution that opposes contraception, like the Catholic Church, it does not have to provide contraceptive coverage to its employees. The second aspect says, for-profit companies that employ more than 50 people and provide insurance coverage to employees had to provide coverage for the 20 types of contraceptives for women approved by the Food and Drug Administration. 2 years ago, in Burwell versus Hobby Lobby, the Supreme Court said this violated a federal statute. The Religious Freedom Restoration Act is applied to close corporations, family-held businesses. The case that's going to be argued in the Supreme Court next week, Zubik versus Burwell, involves the final aspect of the contraceptive mandate. This concerns not-for-profit institutions that are affiliated with religions that oppose contraception. Think of a Catholic university. The regulation says they don't have to provide contraceptive coverage to their employees so long as they file a statement with the federal government that they're affiliated with a religion that opposes contraception. In that case, at no cost to the employer, the insurance provider and the federal government provide contraceptive coverage for women. All over the country, lawsuits were filed by not-for-profits affiliated with religion. They said forcing them to submit the statement to the federal government was a substantial burden of their religion. They said it made them complicit in providing contraceptives. Once they filed that statement with the federal government, then the insurance provider and the federal government provide contraceptive coverage, albeit at a cost to the employer, and such complicity violated the Religious Freedom Restoration Act. 7 federal courts of appeals rejected that argument. 1 federal court of appeals accepted it. The Supreme Court granted review of the first 7 cases, and that's what's going to be argued. One more case that I would talk about where Justice Scalia's absence can make a huge difference concerns immigration. It's a case that's going to be argued next month in the Supreme Court. It's United States versus Texas. In November There's so many ways to take that. In November 2014, President Obama announced his executive action on immigration that's often called DAPA, Deferred Action for Parents of Americans. It says, if there's someone who's not lawfully in the United States, and the individual has been here since 2010 and has no criminal record, they will not be deported for at least 3 years if they have a child who's an American citizen or a child who's a lawful resident alien here. President Obama explained that there are about 11 million undocumented individuals in the United States. Each year, the government deports only about 400,000 of these. So let's focus deportation on those who are dangerous. Let's not break up families. Immediately after President Obama announced this, the state of Texas and 25 other states filed a lawsuit against it. Federal District Court in Texas issued a preliminary injunction. In November 2015, the Federal Court of Appeals, in a 2-1 decision, ruled against the Obama administration and upheld the preliminary injunction. The Supreme Court granted a review. If the Supreme Court here splits 4-4, there's reason to think it might, then the Fifth Circuit decision stands, the preliminary injunction stands, the Obama immigration action does not go into effect. We'll see after oral argument. So those are some of the cases that are most important this year, and you can see as I go through them why Justice Scalia's absence can make such a difference. The third thing that I wanted to talk about this afternoon is the likelihood, the process of filling the vacancy on the Supreme Court. Article 2 of the Constitution says, the President shall take care the laws are faithfully executed. It also says, the President shall appoint, with advice and consent of the Senate, judges of the Supreme Court. Yesterday, President Obama filled that constitutional duty and appointed United States Court of Appeals Judge Merrick Garland. Now, I was driving in my car and I heard somebody say, the President can't make appointments in the last year of a term. There is no such clause in the Constitution. In fact, 24 times in American history, presidents have appointed justices in the last year of a presidential term. In 21 of the 24 instances, the United States Senate has confirmed the individual. Most recently, in 1956, there was a vacancy, and in October, just weeks before the election, President Dwight Eisenhower made a recess appointment of William Brennan to the Supreme Court. He was then confirmed a few months after the November election. In 1940, President Franklin Roosevelt appointed Frank Murphy to the Supreme Court, and he was confirmed. Perhaps the most famous instance of this occurred in 1801. The election of 1800 is enormously important in American history. It was the first time that an incumbent president seeking re-election was ever defeated. That was John Adams, and it was clear that he was the loser in a four-way race. Ultimately, it took the House of Representatives to choose Thomas Jefferson over Aaron Burr. At that time, the presidency changed on March 4th. On January 20th of 1801, just about 6 weeks before leaving office, President Adams named his Secretary of State, John Marshall, to be the Chief Justice of the United States. 7 days later, the Senate confirmed John Marshall. No one at the time, as best we can tell, said, a lame duck president shouldn't fill vacancies on the Supreme Court. Even those who supported Jefferson, the incoming president, didn't object to John Adams filling the vacancy on the Supreme Court. 24 times in American history, a president in his last term has filled a vacancy, nominated to fill a vacancy on the Supreme Court. 21 times the individual has been confirmed. There is, though, no way to force the United States Senate and its Judiciary Committee to hold hearings. There's no way to force the United States Senate or its Judiciary Committee to take a vote. Just hours after Justice Scalia's death was announced, Senate Majority Leader Mitch McConnell said there's going to be no hearings, there's going to be no vote. The senators, the Republican Party, on the Judiciary Committee have all constantly expressed this view. Nonetheless, yesterday morning at 8 o'clock our time, President Obama nominated Merrick Garland for the Supreme Court. Judge Garland is impeccably qualified for the court. Here I should make a disclosure. I've known Merrick Garland since 1969. He and I were competitor high school debaters in the Chicago area. He was also a year ahead of me in law school. Our paths have crossed over the years. He's a brilliant man. He's a truly decent person. My son called me yesterday and said, "You know him, right?" And I said, "Yeah, a little bit." My son said, "What do you think?" I said, "Gosh, President Obama picked a Jewish man in his early 60s from Chicago who was a high school debater and went to Harvard Law School. What's not to like about those demographics?" Also, in selecting Judge Garland, President Obama picked somebody without a liberal paper trail. In fact, Judge Garland, who's been on the United States Court of Appeals for the Disciplinary Circuit for 19 years, is known by every standard as a moderate judge. He has great educational professional credentials. He graduated first in his class from Harvard College, went to Harvard Law School, he graduated magna cum laude. He clerked on the United States Court of Appeals for the Second Circuit for Judge Henry Friendly, the same judge that Chief Justice John Roberts clerked for. Judge Garland clerked for William Brennan on the Supreme Court. He was a partner at the law firm of Arnold and Porter. He also was an assistant United States attorney and later the deputy assistant attorney general who oversaw the criminal division. Having spent the last 19 years on the Federal Court of Appeals, he has spent more time as a federal appellate judge than any other Supreme Court nominee in history. And if you look at his entire record, there's certainly some rulings that will displease conservatives, some that will displease liberals. He's really a moderate. Will Merrick Garland ever serve on the Supreme Court? It's possible that some of the Republican senators who are facing difficult re-elections in November may create pressure for the Senate Judiciary Committee to hold hearings, and that may create pressure for a vote. If a Democrat wins in November, then I think that it is very likely that the Republicans will confirm Merrick Garland in November or December. There's an easy explanation for this. Merrick will turn 64 next November. Imagine Hillary Clinton is elected president. I could imagine the Republicans in the Senate saying, we can confirm this 64-year-old moderate, or we take the risk that Hillary Clinton could appoint a very young liberal. Also keep in mind that the Senate changes hands on January 3rd, even though the presidency doesn't turn over until January 20th. If the Democrats were to take the Senate in November, then they could confirm Judge Garland no matter what happens with regard to the presidency. And of course, even if none of that happens, if it's a Democratic president who wins in November, the Democratic president could then renominate Merrick Garland. So there's many paths that could lead to Judge Garland being on the Supreme Court, but what's going to happen is obviously going to play out in the months ahead. That brings me to the fourth and final part of my remarks, why I believe that the Supreme Court is the most important issue for the November elections. Literally every issue that affects our rights is going to be determined by who is the president especially if it's a two-term president, who fills these likely 4 vacancies on the Supreme Court. I will go through 5 examples quickly. I've already alluded to a number of them. The first that I would talk about is the First Amendment in campaign finance. Citizens United versus Federal Election Commission was a 5-4 decision. The majority opinion was written by Justice Anthony Kennedy, joined by Chief Justice Roberts and Justice Scalia, Thomas, and Alito. Justices Ginsburg, Breyer, and now Sotomayor and Kagan strongly disagree with that holding. If Justice Scalia is replaced by a justice who agrees with the dissenters, I have no doubt that Citizens United will be overruled. In fact, Citizens United explicitly overruled a Supreme Court decision from just 7 years earlier. In McConnell versus Federal Election Commission in 2003, the Supreme Court upheld the same provisions that Citizens United struck down. What changed in those 7 years? Did the court find some musty history of the First Amendment that led it to believe it made a mistake? No, all that changed was Justice O'Connor, who had been in the majority in McConnell, was replaced by Justice Samuel Alito. He was with the dissenters from McConnell to create the new majority in Citizens United. About a year and a half ago, Ruth Bader Ginsburg was speaking in San Diego. She said that she believes that Citizens United will be regarded in history as one of the worst Supreme Court decisions ever. That's saying something when you think the Supreme Court also handed down cases like Dred Scott versus Sanford, Plessy versus Ferguson, Korematsu versus United States. But I agree with Justice Ginsburg here. The ability of corporations to spend unlimited amounts of money from their treasuries to get candidates elected or defeated has an enormously corrosive effect in American politics. We'll never know how many people choose not to run for office because of the fear of the corporate wealth that would be arrayed against them. Whether Citizens United is overruled or whether it remains the law for decades to come will be determined by who is elected president in November. A second example that I haven't alluded to concerns the Establishment Clause of the First Amendment. Long ago, Thomas Jefferson said that there should be a wall that separates church and state, a wall that's high and impregnable. The idea is that our government should be secular. The place for religion is in our daily lives, our churches, our synagogues, our mosques, but not in our government. Justice Scalia did not believe that. Justice Scalia strongly opposed any notion of a wall that separates church and state. He said many times that the government violates the Establishment Clause only if it literally establishes a church or legally coerces religious participation. Only if by law the government forces someone to participate in religion does it violate the Establishment Clause. I believe there are 4 justices on the current court who take that position: Roberts, Kennedy, Thomas, Alito. There are 4 justices who strongly disagree and believe in a wall that separates church and state: Ginsburg, Breyer, Sotomayor, and Kagan. I saw this firsthand a little more than a decade ago when I argued a case in the Supreme Court, Van Orden versus Perry. It involves a 6-foot-high, 3-foot-wide 10 Commandments monument that sits directly at the corner between the Texas State Capitol and the Texas Supreme Court. My argument on behalf of my client, Thomas Van Orden, was that a religious symbol that begins in big letters, "I am the Lord thy God," doesn't belong at the seat of state government. I knew going into that case I had no chance to get Justice Scalia's vote because he believes religious symbols on government property never violate the Constitution. He believes prayer in public schools never violate the Constitution so long as it's so-called voluntary prayer. He believes aid to parochial schools never violate the Constitution. If Justice Scalia is replaced by a justice who takes that position, I think there will be 5 votes for it. I think there will be 5 votes, as there were against my client in Van Orden versus Perry, to allow religious monuments, aid to schools, school prayer. On the other hand, If it's a Democrat who appoints a justice like Ginsburg, Breyer, Sotomayor, and Kagan, or appoints several justices like that, then there will be protection of a wall that separates church and state. Third example, the Second Amendment. There have only been 2 cases in all of American history that have struck down laws that regulate guns. One was District of Columbia versus Heller in 2008. The other was McDonald versus City of Chicago in 2010 that struck down a Chicago ordinance regulating guns. There are 2 very different views about what the Second Amendment means. The view prior to 2008, and of 4 justices on the current court, is that the Second Amendment is a right to have guns for the sake of militia service. The other view, held by 4 who are right now on the Supreme Court, is that the Second Amendment is a right of individuals to have guns, and laws that regulate guns are likely unconstitutional. This is enormously important for all of our safety. What the Second Amendment is going to mean in the future, what kind of gun control laws are going to be allowed, is going to depend on who fills these seats in the Supreme Court. Fourth example is the death penalty. I believe that there are 4 votes on the current court to declare the death penalty unconstitutional as cruel and unusual punishment. In fact, on June 29, 2015, in a dissent in a case called Glossop versus Gross, Justice Stephen Breyer at length made the arguments that the death penalty is unconstitutional. He said there's too great a risk of executing innocent individuals because of wrongful convictions. He said the death penalty is so arbitrary, so it's administered in this country, it's cruel and unusual punishment. He said there's no evidence that the death penalty actually deters crime or has other benefits. Justice Ginsburg joined that opinion. I think if there's a 5th vote, Justice Sotomayor and Kagan also would do so. Justice Scalia wrote a vehement, angry opinion responding to Justice Breyer. He referred to Justice Breyer's opinion as, quote, nonsense, as, quote, gobbledygook. The last sentence of Justice Scalia's opinion was, Justice Breyer wants to appeal not just the death penalty, but the Enlightenment. I think on the current court, Roberts, Kennedy, Thomas, and Alito would continue to find the death penalty constitutional. Whether the death penalty continues to exist is going to depend on who fills the seats on the Supreme Court. My 5th and final example I've already alluded to, abortion. I believe that on the current court there are 3 justices, Roberts, Thomas, and Alito, who would vote to overrule Roe versus Wade. Justice Scalia was among them from the time he came on the court. There are 4 justices who will vote to continue that women should have the right to have safe legal abortions, the right to reproductive choice, Ginsburg, Breyer, Sotomayor, and Kagan. Right now, so much depends on Anthony Kennedy. Justice Kennedy, when he first came on the Supreme Court, voted to overrule Roe versus Wade. But then in the second case before him, he initially voted to overrule Roe, and there were 5 votes to do so, but then he changed his mind and joined with those who were reaffirming Roe versus Wade. But since that case, Planned Parenthood versus Casey in 1992, Justice Kennedy has voted to uphold every regulation of abortion that's come before the court. The consensus among liberals and conservatives is that Justice Kennedy won't be a vote to overrule Roe, but he will be a vote to allow government regulation, likely up to the point of a total ban. Will Roe continue, or will the court overrule it and force especially poor women to choose between unwanted children and unsafe back alley abortions? That's going to be determined by the next election. If there's anything that I would leave you with, it's how much the Supreme Court affects all of us, often in the most important, the most intimate aspects of our lives. That's why I began by saying there is no issue in the coming presidential election more important than who is likely to fill 4 seats on the United States Supreme Court. Thank you.
Thank you very much, Dean Chemerinsky. I'm Ellen Lubick, and I'm an educator. And I find that many American educators worry about Friedrichs and Harris versus Quinn as stepping stones for Vergara cases, which are emerging all over. I'd like you to comment on your view and whether you think these cases are primarily set up to kill the teachers' unions.
There's no doubt that there is an attack on teachers' unions. You mentioned the Vergara case. This is a case that was brought to argue that the statute that provides for teacher tenure in California is unconstitutional. A California Superior Court judge found that the provisions for teacher tenure are unconstitutional as a violation of the California Constitution. The case was argued in the California Court of Appeal a couple of weeks ago. It has to be decided within 90 days after the argument. I wrote a brief on the side of the teachers and the unions in Vergara. There is no reason to believe that eliminating teacher tenure or breaking teachers' union will improve the education for any students in California. You only have to compare states that have strong teachers' union and teacher tenure, like Massachusetts, with states like, say, Texas and North Carolina, where there's no teacher tenure and there's no unions of teachers. The education and the achievement of the students isn't any better in the states without teachers' union and teacher tenure than it is in the states that have it. What we need to do as a society is find a way of making teaching much more attractive as a profession, to attract and keep talented people. Taking away benefits from teachers isn't the way we're going to do it. Certainly, we have to make sure there are mechanisms to weed out those teachers who are not performing well. But you don't need to throw out the entire system in order to accomplish that. But I'm going to use this as a more general point that goes back to my overall thesis. In 1973, in San Antonio Board of Education versus Rodriguez, the Supreme Court held there is no right to education under the Constitution. I'm not caricaturing, that was the holding of the case. It involved a Texas law that funded public schools largely through local property taxes. The result was that poor areas had a tax at a very high rate and so little to spend on education. Wealthy areas could tax at a low rate and had a great deal to spend on education. The Supreme Court 5-4 upheld it as constitutional. The court explicitly declared that there is no right to education. My hope is that a future court will reconsider that. If anything is the key to equality in our society, to advancement in our society, it has to be through education. And so I think more generally we need to look at that case and find a way for it to be overturned.
Dean, thank you. On Left, Right, and Center a couple of weeks ago, Meg Whitman, the former governor of New Jersey, said that when she was appointing judges, she never asked them what their views were with regard to a specific case. I'd like to know your views about whether it's appropriate for a president to ask that question, whether it is being asked, whether it's appropriate for Congress to ask the question where we know it's being asked, and whether it's appropriate for the nominee to respond to questions like what their views would be about Citizens United or Roe versus Wade.
Every president through history has selected Supreme Court justices who are in accord with that president's views. It goes back to the time of George Washington. To say that all of a sudden the appointment process has become politicized is just wrong. It's ahistorical. Some presidents are more defined ideologically. Not surprisingly, they are more attentive to ideology in picking justices. Some are less ideologically defined. Franklin Roosevelt and Ronald Reagan, to pick a Democratic and Republican example, were ideologically defined presidents. Not surprisingly, Franklin Roosevelt and Ronald Reagan picked justices who fit their political philosophies. Dwight Eisenhower was not a particularly ideologically defined president. In fact, until 1952, people didn't know whether he was going to run as a Democrat or as a Republican. So it shouldn't surprise us that he picked a Democrat, William Brennan, for the United States Supreme Court. Just as presidents have always looked to ideology, so has the Senate looked to ideology over the course of American history. George Washington appointed John Rutledge to be the second Chief Justice of the United States after John Jay stepped down. Rutledge had been previously confirmed to be an Associate Justice. But in the interim, Rutledge had said things about the United States being neutral with regard to the war between England and France that the Senate didn't like, and the Senate didn't confirm him. The rejection of nominees on the basis of ideology didn't begin with Robert Bork. In the 19th century, about 20% of presidential nominees to the Supreme Court were rejected by the Senate, almost all on ideological grounds. In the 20th century, you had John Parker, a nominee of Herbert Hoover, being rejected in 1931 because of his anti-union views. You had Clement Haynsworth and Harold Carswell being rejected after President Nixon nominated them. You had Robert Bork. So ideology, of course, is a factor. Is it appropriate for a president or the Senate Judiciary Committee to ask for views on issues? Yes, so long as they don't ask how you're going to vote in a particular case. How a justice is going to vote in a particular case should always be the product of the briefing and the arguments and the facts of that case. So it's inappropriate to say, how will you vote until the case is there? But as to views, I have no problem with knowing someone's views. After all, on abortion, we always knew Justice Scalia was going to vote to uphold the regulation of abortion, and Justice Ginsburg was going to vote to strike it down. The fact that we know their views doesn't require that they be disqualified. So my position is, of course you can ask views. Now, in reality, presidents are more subtle than that. You can find out views from somebody without flat out asking them about it. You can look at their paper trail. You can talk generally about issues. In the Senate confirmation process, well, start with, there's only a meaningful Senate confirmation process, or at least one that's going to be controversial, when the President and the Senate are from different political parties. So long as the President and the Senate are the same political party, it's almost unheard of for the person not to get confirmed. You have confirmation fights when the Senate and the President are different political parties. I don't think our confirmation process works very well. I was a witness. I testified against the confirmation of Samuel Alito in January of 2006. At a break in the proceedings, then Senator Joe Biden came up to me and said, "This is all an exercise in kabuki theater." Those were his exact words. He said, "Everyone in this room knows that Sam Alito is going to be a very conservative Supreme Court justice. But the Republicans are all pretending he has no views and no ideology. And the Democrats are all trying to trip him up with a question that he's too smart to answer. I think we could create a better confirmation process." Wherever the microphone is.
What do you think about Mr. Obama making an interim appointment of Judge Garland?
The question really goes to what's called a recess appointment. And the problem with that is the Senate's not going to go into recess. What the Republicans will do, they're like going on a 2-week spring break now. Every few days, some Republican senator will take the podium, call the empty chamber into session, and then adjourn it. That's what the Democrats did during the last 2 years of President Bush's administration to make sure that he didn't get any recess appointments. Also, the Supreme Court ruled in June 2014 in NLRB versus Noel Canning that a president can make a recess appointment for an intra-session recess only if it's longer than 9 days. The Republicans aren't going to give President Obama the chance to make such a recess appointment. You know who has the microphone, so, okay.
I have it right here. We hear a lot about freedom of religion. What about freedom from religion? I wonder about people who don't profess to any religion having to abide by bosses or companies who impose their religious views on them, like in providing abortion or conception meds or whatever you want like that. I think that's something that's not been addressed fully.
My view, and then we can talk about the Supreme Court and answer to your question, is that the Establishment Clause means that our government should be secular, that free exercise of religion should be protected until and unless somebody's free exercise of religion infringes somebody else's rights. That I don't believe there's a right in practicing your religion to harm somebody else. Now, the Supreme Court, at least with Justice Scalia on the court, had a majority that didn't agree with that. The majority of the court saw very little in the way of an establishment clause. They rejected the notion of a wall separating church and state. And at the same time, they wanted to provide protection of free exercise of religion, even if it was people using their religion to harm others, like in Hobby Lobby denying contraceptives. But I think I can make an argument based on history, I can make an argument based on policy, that the way we should read the Constitution is say, our government should be secular, it should be neutral, that people should be able to practice their religion up to the point where they're inflicting harm on others.
Thank you for the clarity of your speech.
Thank you.
Fantastic.
My pleasure.
I don't know if this is politically correct, but Justice Scalia in the last year seemed particularly uncensored to me. Would you mind commenting on that, your opinion?
No, I don't mind. In fact, I wrote an op-ed in the Los Angeles Times middle of last July talking about Justice Scalia's lack of civility. I mentioned one example, what he said in his dissent, is a concurring opinion in Glossop v. Gross, the death penalty case. But let me quote to you, and these are virtually verbatim quotes from his dissenting opinion in the marriage equality case, Oberfeld v. Hodges. In a footnote, he said that Justice Kennedy's majority opinion was like the aphorisms of a fortune cookie. In the same footnote, he said, if he ever joined a majority opinion with language like Justice Kennedy's, even to get a fifth vote, he wouldn't feel comfortable leaving his house without a bag over his head. He referred to Justice Kennedy's majority opinion as, quote, pompous and egotistical. My position in July, my position today, is that such language has no place in Supreme Court opinions. That Supreme Court opinions are supposed to be reasoned arguments. That's not reasoned arguments. What I said in the op-ed piece was, I think this sends a terrible message to law students and lawyers about how to write and talk with one another. At a time when the bar is thankfully, finally increasing an emphasis on civility, this is the antithesis of that.
Okay, my question is about the Apple security
Sure.
problem.
Sure.
How do you think about that?
Sure. And you're all familiar with what this is about. The most recent, well, here in California, the most recent manifestation of this is a cell phone has been obtained that belonged to one of the terrorists who did the shooting in San Bernardino. The iPhone 5S has a feature that if it's activated, if 10 times the wrong password is put in, the phone gets wiped. And if the feature is activated, it takes longer after each wrong entry to put in the right entry. The FBI doesn't know if this feature has been activated on this phone. If there's a 4-digit password, as it appears this phone has, there are only 10,000 combinations. And 10,000 combinations, you say, well, wow, so many. Actually, it's very easy for a computer to run through 10,000 combinations quickly. So what the FBI wants is a way to deactivate this feature on this cell phone so they can then run through the 10,000 combinations, break the password, and see what's there. Apple says, we don't have the software to do that, and to force us to do that is beyond the power of the court, violates our First Amendment rights. You might have seen a couple of weeks ago, a judge in New York in a similar case involving Apple, came to the opposite conclusion. So that's the issue, and it can come up in all sorts of contexts. My view is, and I said this from the time that came into the press several weeks ago, if Apple has the software for how to deactivate this feature, or someone in Apple knows how to do it, then they have to produce the document or produce the individual to testify. But if Apple is correct in its statement that it doesn't have the software or the knowledge to do that, then the court doesn't have the authority to make them create it. To put it most simply, the court can subpoena what exists, but the court by subpoena can't exist what doesn't exist, can't force something to be created. Apple has said repeatedly it doesn't have the software. I think the larger issue is incredibly difficult and is for Congress to resolve. Should there be the ability to have encrypted communication that law enforcement can never have access to? Law enforcement says there has to be a way of breaking any encryption. Terrorists use encryption so that their communication can't be heard, read, scrutinized. On the other hand, Apple and privacy experts say, once you create the way of breaking the encryption, it's not just the good guys who will be able to do it, the bad guys will be able to do it as well. And repressive governments, like in China and Pakistan, can use this to great harm. So the government is going to say to Congress, you should make sure that for any encryption, there is some key that law enforcement can use. Apple privacy experts say we should allow encrypted communication without any key. I think that's the question, and that Congress is going to have to resolve, but it's what underlies this dispute with regard to Apple. And again,
Hello?
you have the microphone.
Yes, I have it. I would like to hear the status of voter ID requirements. Is it state-controlled still? Is there any federal law that will enable voters to vote without having photo ID or any other required ID? Thank you.
Sure. In 2008, in a case called Crawford versus Marion County, Indiana, the Supreme Court considered a challenge to an Indiana law that requires showing photo identification in order to vote. This was a bill that was passed with the support of every Republican in the Indiana legislature, opposed by every Democrat in the Indiana legislature. The reason is that photo ID laws tend to help Republicans by disqualifying minorities who tend to be predominantly Democratic voters. The lawsuit was filed as soon as the Indiana law was passed, and the Supreme Court 6-3 upheld the Indiana law. The court said there was no evidence that the Indiana law was keeping people from being able to vote because the challenge was brought before the law had the chance to go into effect. In fact, you might have seen in June of 2008, when Indiana held its presidential primary, there were a group of nuns who were denied the right to vote because they didn't have driver's licenses or any form of photo ID. But there can still be challenges to voter ID in a couple of ways. One is to say that once the law has actually gone into effect, as applied, it is unconstitutional. The other is to say that it violates a federal statute, the Voting Rights Act of 1965. The Voting Rights Act, in Title II, says there cannot be election practices or systems that have the effect of discriminating against voters on account of race. A number of lawsuits were brought and are now pending challenging voter ID laws on both of those grounds, that as applied, they're keeping people from being able to vote, and they violate the Voting Rights Act of 1965. In fact, in October 2014, a federal district court judge in Texas issued a preliminary injunction against the Texas voter ID law. Texas was the strictest voter ID law. It wouldn't use student IDs to be able to vote. it wouldn't even allow military IDs for somebody to vote. And the federal trial court judge in Texas found that about 600,000 eligible voters, overwhelmingly African American and Latino, would not be able to vote as a result of this law. She said it likely violated both equal protection under the Constitution and the Voting Rights Act. The Supreme Court, without opinion, on Saturday morning, October 25th, 2014, allowed the Texas law to go into effect. Now, that isn't a decision on the merits. There's cases coming forward from Texas, and the Federal Court of Appeals has recently granted what's called en banc review of all of the judges on that court of the Texas law. Wisconsin and North Carolina, they're all making their way to the Supreme Court. They won't get there this term, but they might get there next term.
I had just a quick logistical, future-telling question. Judge Garland has been nominated now, and it looks like the Republican Party is opposing any kind of action. Let's suppose that that condition remains until the election, and let's suppose a Democrat does, Hillary Clinton or Bernie gets elected, and the Republicans still don't approve him. When the new president takes office, does he or she have to keep that as keep him as the same nominee?
No.
And how will he feel if somebody else is chosen?
Any nomination by this president expires at the end of this president's term. It'd be up for the newly elected president whether to renominate Judge Garland or nominate somebody else. As I mentioned in my remarks, I think that if a Democrat wins the White House, the Republican Senate will confirm Judge Garland in November or December. That's because they'd rather have a 64-year-old moderate than a much younger liberal who Hillary Clinton or Bernie Sanders president could appoint. In terms of how Judge Garland feels about this, he knows the political reality as much as all of us. You know, I admire him for allowing his name to go forward, knowing the uncertainty of confirmation and knowing that he's making himself a target in the coming election. But you know, whether it was a good gamble from his perspective on his part, I think will depend on what happens in the months ahead.
Hi. I have a question also, which would let's assume that the complexion of the presidency is going to be occupied by a Democrat, and therefore the court is going to change. Do you think there's any chance of overturning Heller and McDonald? I mean, it would be one or the other, but do you think there's an opportunity for that?
Yeah, if either is overturned, both are overturned. Right. Heller is just the case that says the federal government can't regulate guns in a way that keeps people from having them in their homes for the sake of security. McDonald's is the case that says state and local governments can't do so. But they say the same thing. It's just one deals with the federal government and one deals with state and local governments. Yes, I think so. Remember, as I said, from 1791 to 2008, not one law gets struck down as violating the Second Amendment. So I think that if a Democrat replaces Justice Scalia, and certainly if a Democrat replaces, say, Justice Kennedy, so you have a solid majority, they'll say District of Columbia, Heller, and McDonald versus City of Chicago were anomalous decisions. They departed from an almost more than 200-year history, and we're returning to what the law had always been. And so, yes, I think that they would overrule those decisions. Just as I think that the liberal majority, if it's there, will overturn Citizens United, saying they're returning to what the law had been even 7 years earlier. But I think a conservative majority is going to overrule Roe versus Wade. I think a conservative majority is going to eliminate affirmative action. So that's why this election is so important.
Good afternoon, Dean Chemerinsky. Thank you so much for your time. Oh, sorry, I'm over here.
I'm trying to figure. Oh, there you are. Hi.
So I'm a staff member at Mazona, Jewish Response to Hunger. So of course.
And I was on the board of directors for that for a number of years.
Lovely to meet you. I'm a new staff member. But so as you are very well, oh, I'm sorry, I'm moving my hand too much. As you're very well aware, we're especially concerned with what we consider the right to minimal entitlements, like the access to adequate nutritious food. Do you see that as something that SCOTUS would ever rule on or have it pay attention to?
I believe that had the Warren Court lasted a few more years, it would have found that there is a right under the Constitution to minimal food, shelter, medical care. Most of the constitutions that have been written in recent decades expressly include such a right. If you look at the South African Constitution, for example, it's explicit, but the right to what you call minimum entitlements, as well as to a clean environment, into education. I think it's not something that even a Democratic majority on the Supreme Court's likely to do in the short term. I think there's a lot of groundwork to have to build up to it, but I think that in accord with the International Covenant of Human Rights, in accord with the Constitution of other countries, it's something that could happen in the future. So your question to me was, do I ever, that was your word, ever's a long time. And, you know, wasn't it Martin Luther King's quote, it's a wonderful one, that the arc of history bends towards justice? That's my answer to your question.
Good afternoon. I'd like to ask a question of you as a apolitical law professor.
There's no such thing. No one's apolitical.
Let's try. Intellectually, would you prefer to see a 5-4 court or a 4-1-4 court?
I think there's always a benefit to having a majority opinion. So if what you mean by 4-1-4 is 4 justices in the plurality take a position, a 5th justice joins as to the result but different reasoning, in 4 dissent, I think that creates real confusion in the law for lower courts, for legislatures. So I like majority opinions rather than plurality opinions where there's no majority. In terms of the court, you know, is it better to have 5 justices of a position and 1 swing justice or 2 swing justices? I don't have any views as to that. I just want to see majority opinions. I think it's better for the law to be clearly settled so that lower courts know what to do and legislatures know what to do.
My question is about your comment about the use of religious symbols such as the Ten Commandments. And are there times when religious symbols become important cultural, historical, cultural things too, particularly in the case of Ten Commandments because they reflect universal values? I'm thinking of the niyama, nonviolence, truthfulness, non-stealing, continence, and non-greediness, which are pretty much that's just one example of,
Sure.
And would it make a difference if other other codes of law were displayed in conjunction with the Ten Commandments?
Sure. As to the former, one of the things I learned from litigating this case in the Supreme Court is there is not one version of the Ten Commandments. You may already know this, that the Jewish version of the Ten Commandments is different from the Catholic version of the Ten Commandments, which is different from the Protestant, say, Lutheran version of the Ten Commandments. And the differences are quite important to theology. So, for example, while the Jewish version and the Protestant version say, thou shalt not have false idols, that provision is not in the Catholic version of the Ten Commandments because of the importance of statuaries within the Catholic religion. The Jewish version of the Ten Commandments says, I am the Lord thy God who took you out of bondage in Egypt. That's not in the Ten Commandments of the other religions. There's a difference in terms of whether it says kill or murder in the Ten Commandments. So in Texas, they had the Protestant version of the Ten Commandments. To me, that's a choice of religion. Also, if you go back and you read the Ten Commandments, the first 5 of them are religiously oriented. Thou shalt know the God besides me, no false idols, observe the Sabbath. The latter 5 provisions of the Ten Commandments are much more the universal, thou shalt not steal, thou shalt not commit adultery, and the like. But the Ten Commandments are still sacred religious text. My position was that sacred religious text doesn't belong at the seat of government. As to your latter question, absolutely it depends on how they're depicted. If there's a depiction of all sorts of different sources of law, and the Ten Commandments among them, I don't see a problem with that. If you look at the frieze that runs around the Supreme Court room, there's Hammurabi and his code, and there's Muhammad, and there's Moses holding the Ten Commandments. No problem with that. It's about lawgivers. But in the case that I argued, at exactly the corner, it's the Texas State Capitol and the Texas Supreme Court, and they're perpendicular to one another. Facing outward is the 6-foot-high, 3-foot-wide Ten Commandments monument. That's not just a display about different sources of law. That's something quite different, putting scripture at the seat of Texas state government. That's what I objected to.
The DAPA decision that you referred to, you said was made by a 2-to-1 decision.
Correct.
Now, I understand that the Senate has refused to consider many of the nominations that Obama has made to this point. So this is not a new thing with regard to the Supreme Court. Is that correct?
I'm sorry. I think there's
court
two
appointments.
Right, yeah.
Lower court appointments.
The Senate, I think there's now over 90 vacancies on the federal district courts and the federal courts of appeals. The Senate Judiciary Committee is moving very slowly in considering President Obama's nominees, and likely will shut down the whole process by about June. Now, the problem with that is there are courts that are desperately understaffed because of judges dying and retiring, and those vacancies not being filled really has an effect on people and being able to have their cases heard.
If Donald Trump is elected president, what effect, considering the language he espouses, how he treats fellow Republican opponents, what effect do you think that will have upon the Constitution and upon the concept of democracy in this country and around the world?
I don't know.
I know that you have alluded to it, but I was brought up with separation of church and state. What happened? When did it change that some political nominee could be talking about his religion to make an influence?
Antonin Scalia played a key role with regard to this. Also, the justices who have been appointed by Presidents Reagan and both Presidents Bush had a real effect on this. In 1947, in a case called Everson versus Board of Education, all 9 justices said that the Establishment Clause is about a wall that separates church and state. Today, we have 4 justices on the court who reject that notion. Unless you think this is just hyperbole, let me tell you about the last Supreme Court case that involved this. It was 2 years ago. It's a case called Town of Greece versus Galloway. The town of Greece is outside of Rochester, New York. It's about 100,000 people. Beginning 1999, every month they invited a local clergy member to deliver a prayer before the town meeting. For 8 years, every month without exception, they invited a Christian clergy member to deliver that prayer. Some people objected, and for the next 3 months, they invited non-Christian clergy members. Then for the next 18 months, they reverted and invited only Christian clergy members. The prayers were almost always explicitly Christian in their content. A challenge got brought saying that this violates the Establishment Clause. The government had become impermissibly aligned with Christianity. The Supreme Court, 5-4, upheld the town of Greece practice. Justice Kennedy wrote the opinion for the court. Justice Scalia wrote a concurring opinion and said, the Establishment Clause is violated only if the government by law forces people to participate in religions they disagree with. That leaves almost nothing of the Establishment Clause. And I actually think there's 4 justices on the court right now, Roberts, Kennedy, Thomas Alito, who just don't believe in a wall that separates church and state. So this is a place where the next appointment can matter enormously.
Hello, this is going to be our last one question here.
If I recall, Justice Kennedy wrote the opinions of striking the death penalty for juveniles and mental retardation. I was wondering why you thought he wouldn't go further. And by the way, I just finished a case with your son. I found him to be very honorable and fair prosecutor.
Oh, good. That's the nicest praise. I can say nice things about my kids. He's a federal prosecutor. He's an assistant U.S. attorney in Los Angeles. Justice Kennedy wrote the opinion in Roper versus Simmons in 2005, saying that the death penalty for crimes committed by juveniles is cruel and unusual punishment. He wrote the opinion in 2008 in Kennedy versus Louisiana, saying that the death penalty for the crime of child rape is cruel and unusual punishment. The death penalty just has to be for murder. But he was also part of the majority in Glossop versus Gross on June 29, 2015, saying that the drugs that were used for lethal injection weren't cruel and unusual punishment. I don't see anything in his opinions that indicates that he would find the death penalty inherently to be cruel and unusual punishment, just that certain applications of it are cruel and unusual punishment. On the other hand, a number of justices, as they've gotten to be in their 80s, near the end of their tenure on the court, have come to believe the death penalty is always unconstitutional. Justice Brennan and Marshall said that. Before leaving the court, Justice Blackmun said that very famously in language. He said, "I'll no longer tinker with the machinery of death." Justice Stevens said that before leaving the court. Now Justice Breyer, though he's younger, has said that. Justice Ginsburg joined that. Might Justice Kennedy come to that view? Maybe. We just haven't seen evidence of it yet. Thank you so much for having me.
Thank you. Thank you very much.